good morning, Judge. So Gretchen and I conferred. There's still some discovery stuff that we're dealing with. And I also wanted to let the court know I had submitted an ex parte motion. I filed it and then I emailed it to you prior to the holidays. And I've looked through and I don't think that I received anything back. That doesn't mean that you didn't rule on it, but I never got anything back. So, but I'd like just to reset so I can do what I need to do with my expert. And then Gretchen and I have continued to work on this case as well.
Okay. Let's do February 28th, and I will look through. I did sign it. I do remember signing it.
I'm sure you probably have mountains of those, but and I don't know whether it got sent to me and I somehow just missed it.
If it's sealed, and I specifically tell them, hey, we need to send this to Kathy, they probably.
Okay. Well, I was kind of keeping a lookout. So, and I definitely will too this week for sure.
Okay, sounds good. Thank you, Kathy.
All right. Judge, could I have a breakout with my client just to let him know what's happening as he's a Spanish speaker, and then could we lead from there, or do you need him back in? Okay.
No, I can leave.
I'll let him know. Thank you.
Mr. Brown, I know you said you don't live in Bexar County. Where do you live?
I live in Killeen, Texas.
Yes, we've gone over that, Judge. He does live in Killeen, but he's willing to drive in for the 4 Saturdays to participate in the Bear Gives Back program in exchange. Instead of going in to custody, he said he is willing to participate in the Bear Gives Back program.
How many days does he have in?
Only 1, Judge. So that's why he's willing to put forth the effort to participate in the program and drive from Killeen.
The program starts at 8 in the morning.
I'll be here at 7:30.
That's a long drive.
I mean, I stayed down here in San Antonio for like 10 years, and I just recently moved back to Killeen because my living situations down here wasn't suitable for me to survive. But I work at Denny's down. I was working at Denny's down here for 6 years downtown, and I love my job, so I kept driving back and forth 5 days a week, just to keep my job and be able to still survive and do the right thing. But it just got unlivable. So now they transferred me to Austin. So now it's like I drive an hour back and forth to work in Austin every day. I mean, like in order just to keep my job, because I love working my job, I'll drive them those hours. I'll take that.
Okay, well, let's try it. Let's go on the record, David. This is cause number 2021 CR 8636, the state of Texas versus Jeremy Brown. Attorneys, please make your announcements for the record.
Gretchen Plater for the state.
Megan Enriquez for Jeremy Brown.
Mr. Brown is appearing by video conference. Go ahead and tell me your full name, Mr. Brown.
My full name is Jeremy Lamont Dwayne Brown.
Thank you. On the screen, I have the true bill of indictment that was filed in your case. It alleges the offense of possession of a controlled substance and penalty group 1 less than a gram. That's a state jail felony. Do you understand the charge that you have? Oh, sorry, switched over to Sue. That's the indictment. Do you understand the charge that you have pending?
Yes, ma'am. Yes, ma'am.
Okay.
Yes, I do, Your Honor.
The state jail felony is punishable by confinement in the state jail facility of the Texas Department of Criminal Justice for any period between 6 months and 2 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies to your case?
Yes, Your Honor.
You have the right to a jury trial on that charge. You have the right to cross-examine the witnesses against you, and you have the right to remain silent. Those are your constitutional rights, Mr. Brown. Do you understand them?
Yes, Your Honor.
When you sign this document I have on the screen called the defendant's waivers, what you're telling me is you want to give up those rights. Is that what you intend to do?
Yes, Your Honor.
Is this your electronic signature?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
If you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Brown, are you satisfied with the representation of your attorney?
Yes, Your Honor.
Ms. Enriquez, does your client have a rational and factual understanding of the proceedings against him?
Yes, I believe he does, Judge.
Has he been able to assist you in the preparation of any defenses?
Yes, he has, Judge.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
Yes, I believe he is.
I will accept the waiver and make it part of the record. Mr. Brown, on the screen, I have your plea bargain agreement. I'm going to go over it with you, and then I want you to tell me if that's your understanding.
Okay.
It calls for 180 days confinement in the Bexar County Jail. No fine, no application. You agreed to participate in the Bexar County Gives Back program, which means
Yes.
that your jail sentence is suspended. You don't have to do the time. You just have to participate in the program. Is that your understanding of the agreement?
Yes, Your Honor.
Ms. Enriquez, is that your understanding?
Yes, it is, Judge.
And state, Ms. Waiter,
Yes, Judge.
what is your plea to the charge of possession of a controlled substance, penalty group 1, less than a gram? Is it guilty, not guilty, or no contest?
No contest.
Are you entering a plea of no contest to this charge because you have talked to your attorney and you believe this plea is in your best interest?
Yes, Your Honor.
Has anyone forced you to enter a plea today
No, Your Honor.
or offered you anything in exchange for your plea?
No, Your Honor.
I will accept the plea of no contest. I do find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers Exhibit 1 and its attachments.
No objection, Judge.
States 1 is admitted. Ms. Enriquez, are you satisfied the state complied with Article 3914 in this case?
Yes, Judge.
I will sign the discovery acknowledgement and make it part of the record. Give me just a minute, please. Mr. Brown, when you're finished with this, I need you to come back in the courtroom so we can tell you how to log on to Zoom so that you can join us on Zoom on Thursday. So just hang tight.
Okay.
Let's go back on the record. I do find the evidence is sufficient to substantiate your guilt. I will find you guilty of the offense of possession of a controlled substance, penalty group 1, less than a gram. And I will sentence you to 180 days confinement in the Bexar County Jail pursuant to 1244. The sentence will be suspended. You're going to be allowed to participate in the Bexar County Gives Back. That is beginning this Saturday. January 22nd. Mr. Brown, I followed your plea bargain agreement in this case. So what that means is you do not have a right to appeal. Do you understand? You have to unmute yourself to give me an answer.
Yes, Your Honor.
Okay. With that, we're going to go off the record. You can come back in the courtroom. We can tell you how we're going to proceed on Bear Gets Back.
Judge, would you like me to be present for that, or am I excused?
No, I'm just going to make sure he has Zoom because he has to Zoom in on Thursdays. You're good.
Okay, thank you, Judge. If you need anything, let me know. Bye-bye.
Judge Manny joined.
He needs to confer with Mr. Cunningham.
Your Honor, may I approach when possible?
Yes. Do you have a way to get on Zoom? You have to download the app on your phone.
Okay.
Yes, Victoria, go ahead.
Thank you, Your Honor. I've conferred on Jonathan Alcala. He's an inmate. He is logged on. We need to keep that on the trial docket. We have an offer, but we're very, very far apart. State has asked for a counter offer, and we're gonna work on that. If I may have a reset on the trial docket, Your Honor.
March 21st.
Thank you. And may I be placed in a breakout room and excused from there?
Scratch that, February 28th. He's in custody.
February 28th trial. Well.
Okay, what else, Victoria?
May I be placed in a breakout room with him and then excused from there, please?
Yes, thank you.
Is it Manny Rodriguez that got appointed on Cunningham?
Yes. Do you guys have the deal on Tommy Reyes for me to put it on the paperwork?
Yeah, I think he has 102 days credit on at least one of them. So we'll do 200 days, Bexar County Jail, 1244A.
Melinda, you didn't put a number on the 11489 case. Are they all the same?
That's 200 days. I mean, I'm sorry, 102 days.
Oh, I'm sorry. I see that now. Okay.
Gretchen, are you willing to TSC the second one?
I can't. He already pled to it.
We're going to run concurrent.
Yeah.
Right. That was a new case. I'm gonna go back to the breakout room and discuss it with my client.
Okay. I already started changing it on the plea paperwork. I'm ready on Jason Rodriguez.
He's in 4, Mr. Sepulveda. You just have to go back.
Ashley, can you put Alcala in 2? I'm in there already, please.
On Jason Rodriguez, he's going to plead on the evading and assault violation of bond or protective order and dismissing the drug case.
It should be 3 cases, but yes, I believe it. We are dismissing the drug case.
You said we're dismissing 2 cases?
No,
No, the drug case.
we signed on 3 separate charges. One's an ag assault, one's a violation of protective order, and the other is a evading. Is he missing any of that paperwork?
No.
I'm just confirming. I have
Okay.
it. I know what to pull up.
So the conditions are a little bit different on a few of them, Judge.
Okay.
Just what makes sense with what case. And then on the VPO, I just put in the conditions, same as the ag assault, yeah.
On the violation of bond protective order, you're proceeding on the violation itself or the assault of a pregnant person?
Both.
The ag assault also has 2 counts, ag assault and assault of a pregnant person.
We'll do the ag assault on that one. Sorry. I don't have the family violence cases, and so I'm doing their paperwork for them. Sorry about that.
So this is the ag assault indictment.
Yeah, they don't save it in JD like we do, so it's all messed up. Sorry about that.
This is a separate assault of a pregnant person. It's a different date. Looks like the same girl.
So we'll just do the ag assault on that one, and both on the protective order because they're the same degree.
And then the evading is okay.
Normal.
Is there? Tipsy? What's your advice here?
Mr. Castañon, is there a protective order on the civil side on any of these matters?
Not that I'm aware of, Judge.
The victim is non-cooperative, so I would assume not.
The indictment alleges a violation of the bond protective order, but I don't see the emergency order of protection, so I'm gonna probably have to dig it out through the night mag number that it was issued under, or the criminal magistrate number. So.
Is Sam still on?
It should be. Normally those stay on with the indictment, but I don't see it in any of his cases. And it's like 6 months from the date it was issued to the day it was alleged to have been violated. We normally don't give 6 months protective orders. Did you ever, in your discovery, is there a protective order attached? Do you know?
I didn't see anything, but I don't know.
I'll check, Judge. I don't believe I actually saw that.
The most that the emergency protective orders are valid for is 120 days.
Is Sam here? Or?
Is there any way that my people can call you?
I believe he logged off, Judge. Gary Truck's guy was the last person, and they're both going to come on at 1:30.
He needs to come on. I need a copy of the protective order that they're alleging in the indictment because it's not on file 360.
Yes, sir.
If you guys find it while I do Mr. Reyes, let me know. Ready on Reyes? Where is ready, Mr. Sepulveda on Reyes?
Yes, Your Honor, we're ready.
Okay, David, let's take a record on this, please.
Oh, I figured it out, Judge. So he was arrested on another assault family violence case on 9. Oh, no, never mind.
Right, so
it's a violation of bond, though, is it not, for no contact order?
No, but the indictment
The indictment
alleges an emergency order of protection.
I don't think I actually have a copy of that indictment.
He had to have been arrested and formally given the copy of that protective order. But let me see.
Maybe he wasn't arrested.
We don't issue those unless they're in person.
Maybe he wasn't arrested on the ag assault until later.
Yeah, I see it alleges a magistrate order for emergency protection under cause number 083413. Is that the night mag or the criminal magistrate? Those are only issued when the defendant is there in person in front of the magistrate. So I'm sure it was issued if it's alleged. We just need to find it, please. We have to make sure it actually is a violation. You see, it says it was signed on May 12th, so go 120 days. I think that's a little more than 120 days till September 6th when he violated it by.
I have that he was magistrated on June 28th.
Then he must have, then maybe it was a misdemeanor that they issued the emergency protective order on May 12th. Does he have a booking for May 12th? Okay, I'm gonna go on to Tommy.
Sorry.
That's okay. Mr. Reyes, Let's go on the record, David, please. This is cause number 2021 CR 11489 and 2021 CR 4917. The state of Texas versus Tommy Reyes. Attorneys, please make your announcements for the record.
I'm gonna move.
Later for the state.
Jesse Sepulveda for Tommy Reyes.
Okay, Mr. Reyes is appearing by video conference from the Bexar County Jail. Go ahead and tell me your full name, sir.
Tommy Lee Reyes.
What's your name in court?
Mr. Reyes, we are here for sentencing. I had accepted your plea of no contest back on December 27th, 2021. On both of these cases, both of these charges are possession less than a gram. You had applied for deferred. We reset it for a TAP evaluation, but I understand that you want to proceed on a different sentencing recommendation, which is 200 days in the Bexar County Jail pursuant to 1244. Is that what you want to do today, Mr. Reyes?
Yes, ma'am.
So you don't want the deferred. You're going to take the 2 convictions.
Right, correct.
Okay. I did accept your plea of no contest in both of these matters. I found the evidence was sufficient to substantiate your guilt. I'm going to find you guilty in cause number ending in 11489. I find you guilty of the offense of possession of a controlled substance, penalty group 1, less than a gram. In cause number ending in 4917, I also find you guilty of the offense of possession of a controlled substance, penalty group 1, less than a gram. In both of these cases, I'm going to sentence you to 200 days confinement in the Bexar County Jail. Pursuant to 1244 of the Penal Code, you do get credit for the time that you have been in custody on each of these cases. There is no fine. This will run concurrent. They will run concurrent with each other. So in cause number ending in 4917, it will run concurrent with the cause number ending in 11489. And in cause number that ends in 11489, it will run concurrent with 4917. You made a plea bargain in both of these cases, Mr. Reyes. I followed your plea bargain agreement. Do not have a right to appeal. Because you are getting credit for the time that you have been in custody, I do find that the judgment is satisfied in both of these matters. If you have nothing else pending, you should be released today.
Thank you.
Thank you. Mr. Reyes.
Yes, ma'am.
I apologize. I'm not sure if I already said it. This is a plea bargain case and you do not have a right to appeal either one of these matters. Do you understand?
Yes, ma'am.
Okay, thank you. You're excused.
All right.
And the excuse as well, Your Honor.
Yes, thank you, Mr. Sepulveda.
Thank you.
Mr. Mays, I know I've made you wait all morning, but because this is an opposed application, I need some more information on something that the TAP is recommending. And I've called personally. I know the chief of probation has called personally. We're just trying to get our bearings. Can I call you guys back at 1:30? Can you log on back at 1:30?
Yes, Your Honor, I can go ahead and log on at 1:30.
Okay.
Also, Your Honor, could I be put in with Mr. Figueroa, Jesse Figueroa?
Yes, Ashley can do that. Can you call the jail and see if she can have some lunch?
Okay.
And bring her back at 1:30.
I listened to Rodriguez.
Uh-huh.
Yes, he was booked on.
Judge. And Gretchen, can you hear me?
Yes.
I'm reading the warrant on that case. It looks like it was an active condition of bond from the aggravated assault.
That's not
Are
how
you
they
talking
allege
about
the indictment.
Rodriguez?
Yeah.
Yeah, it was. So that's what I didn't read the indictment. I didn't have a copy of it. I thought that that's what it was indicted under, as a violation of bond, because there's a no contact order.
No contact order, yeah.
Which was, he given to him when he was magistrated on May 12th.
And I see that I see that in the warrant also. It says active condition of bond.
Okay, well, Sam or Josh need to get on. Somebody needs to get on because this isn't our case and I don't know what to do.
For each case that you go over these,
You guys see the indictment now, right? You see where it says violation of an emergency order of protection.
Yeah, can we just have it come back at 1:30 since they're not responding to anything?
Can you do that, Orlando?
I'd rather not, but I mean, if we have to, we can. But yeah, I mean, I'd like to resolve it as today. I don't want to
I
come
think
back.
you can resolve it, just not, I mean, I guess you guys can always go on the assault of a pregnant person count 2.
Or they could also amend the indictment without objection.
We can go on the count 2, the assault of a pregnant person. That's fine.
I got a hold of Sam. He'll be joining us right now. He's looking for the EPO as well.
Okay, great.
Yeah, I didn't see an order of emergency even under the criminal magistrate number. No, I don't think you can go on that count at all. If there was no violation of, there was no emergency order of protection, then there's no, that new assault is not a violation. So you can go just on the new assault. You can't even amend count 1.
Okay, well then I probably need to be put in a breakout room with my client just so I can talk to them about that.
Yeah, so I mean, if there is evidence to substantiate the assault of a pregnant person from September 6th, then yeah, it's on count 2. Yeah, if you can put them in a breakout room, please, Ashley. And Orlando, I have a judges meeting that starts at noon, so I'll do your plea, but just I need to know really quick.
Yes, Judge.
Thank you.
Counsel for each case.
Who else? Mr. Rodriguez on Cunningham. Thank you for logging on.
You're very welcome. I think I understand the situation.
Okay.
I was just sent the indictment. I did want to inform the court that I think this has all come to a surprise to Mr. Cunningham. He is not wanting to talk to me this morning. He's instructing me to talk to his power of attorney person, which is his mother.
I mean, Mr. Cunningham, we've had that talk already. I told you Mr. Vinny withdrew. So I had to appoint someone else. I had given him some time to hire somebody. He didn't hire anybody. I will talk to both of you in a breakout room if you give me a few minutes, please.
Absolutely. Thank you, Judge.
Bianca, do you have a compliance report that I can look at? Samuel, you need to talk to Gretchen, please.
Will do, Judge. Put you in a breakout room?
I think Ashley can put you guys in.
Okay.
Go through it. Sorry. So you go through it. Oh, this is me. I clicked the wrong one. So you signed it? What's going on? Yeah. Don't open them up, because then they can open theirs. Where do I go from here? Where do I go from here? What's your name? Okay. Well, I appreciate all your help. Thank you.
Okay, Judge, are you there?
All right,
Judge,
do you guys know what we're doing?
I spoke with my client and he's agreed to proceed on count 2. So I don't know if we need to redo paperwork or just go on record that we're going to be proceeding on count 2.
That's easy to add. So we can just scratch through the violation. Oh, sorry, let me share. We can strike through the offense, and I can put the offense in count 2, and then it doesn't change the punishment recommendation. And then here I can put prosecution proceeds on count 1 right here.
Count 2.
Count 2.
Sorry, count 2.
That's okay.
Thank you, Judge. Sorry about that.
Is that something we could do? That'll fix it.
Yeah, I spoke with him and he's agreed to move forward that way.
That's
All
fine
right.
with me. Sorry about that, Judge.
That's okay. Let's go on the record. Did you tell them on Florida's to feed her because she's pregnant?
Yes.
Thank you. You know, I'm gonna ask her, right? I'm gonna ask her when I see her at 1:30. It'd be better. Might wanna clear people out. All right, let's go on the record, please. We're going to start with cause number 2021 CR 10113. And we're also going to go on cause number 2021 CR 10114 and 2021 CR 6205. All of these are the state of Texas versus Jason Jeremiah Rodriguez. Attorneys, please make your announcements for the record.
Gretchen Plater for the state.
Orlando Castañon for defense.
Mr. Rodriguez is appearing by video conference. Go ahead and unmute yourself and tell me your full name for the record.
Jason Jeremiah Rodriguez, Jr.
Okay, on the screen, I have the first indictment that we're going to talk about. This is the indictment that ends in cause number 113. It alleges in count 1 the offense of aggravated assault with a deadly weapon, and then in count 2 an assault.
Okay, you can
on
go
a pregnant
leave
person.
room now and go back to the main room.
It alleges the offense in count 1 of ag assault with a deadly weapon and count 2 assault on a pregnant person. Do you understand this indictment, Mr. Rodriguez?
Yes, ma'am.
On this indictment state, are we proceeding on which count? Sorry.
On count 1, Judge.
Count 1 is a second-degree felony. It is punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period between 2 and 20 years confinement. It also alleges a possible fine of up to $10,000. Carries a possible fine of up to $10,000. Do you understand the charge in this indictment?
Yes, ma'am.
Let's move on to the next indictment, which is the indictment ending in cause number ending in 114. Count 1 alleges violation of bond or protective order. Count 2 alleges assault of a pregnant person. How are we proceeding, state?
Proceeding on count 2.
No objections from defense, Judge. I
Count
spoke with my
2.
client and he's aware.
Okay. Count 2 is a third-degree felony, punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period between 2 and 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment in count 2, which is assault of a pregnant person?
Yes, ma'am.
The third indictment alleges the offense of evading arrest or detention in a motor vehicle. That is a third-degree felony, and that is also punishable by confinement in the Texas Department of Criminal Justice, the institutional division, for any period between 2 and 10 years confinement and a fine of up to $10,000. Do you understand that range of punishment?
Yes, ma'am.
All right. The way we're going to do this plea, Mr. Rodriguez, is I'm going to go over all of your paperwork with you. And when I ask you a question, it applies to all 3 cases. So if I ask you if you understand your constitutional rights, that applies for all 3 cases, okay?
Yes, ma'am.
For purposes of the record and cause number ending in 114, on page 1, I am going to strike through the offense description, strike through violation of bond protective order, and instead put in there, I'm going to handwrite assault on a pregnant person. That's count 2. And then on the plea bargain page, I will check the prosecution and then proceed on count 2. Is there any objection to that correction from either side?
No objections from the state.
No objections for defense.
All right. So, Mr. Rodriguez, in each of these cases, you have the right to a jury trial. You have the right to cross-examine all the witnesses against you. You also have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes, ma'am.
When you sign this document that I have on the screen, what you're telling me is you're going to give up those constitutional rights that I just described to you. Is that what you intend to do?
Yes, ma'am.
In the cause that ends in 114, is this your electronic signature above J. Rodriguez?
Yes, ma'am.
In a cause number that ends, in 6205, that's the evading arrest. Right here above J. Rodriguez, is that your electronic signature?
Yes, ma'am.
And in cause number ending in 113, is this your electronic signature above J. Rodriguez?
Yes, ma'am.
And are you, did you understand that when you signed your signature on these documents, that's what you're telling me, you're going to give up your constitutional rights?
Yes, ma'am.
And that's what you want to do today?
Yes, ma'am.
Are you a citizen of the United States?
Yes, ma'am.
If you were not a citizen, I'm still required to tell you by law that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Rodriguez, are you satisfied with the representation of your attorney?
Yes, ma'am.
Mr. Castañon, does your client have a rational and factual understanding of the proceedings against him?
Yes, Judge.
Has he been able to assist you in the preparation of any defenses?
Yes, Judge.
And in your opinion, is he mentally competent to waive his rights and enter into a plea?
That's fine.
I believe he is.
I will accept the waiver of rights and make it part of the record. All right, Mr. Rodriguez, I'm going to go over the ag assault deadly weapon plea bargain agreement. It is a pretty loaded agreement, so I want to take them one at a time.
Yes, ma'am.
The ag assault deadly weapon plea bargain agreement calls for a recommendation of deferred adjudication for a period of 6 years, $1,000 fine, an affirmative finding that a deadly weapon was used in the commission of the crime. The state is going to run this concurrent. So the ag assault deadly weapon will run concurrent with the assault of a pregnant person and the evading arrest and 2 other misdemeanor cases listed here, 660-953 and 668-719. The state is going to dismiss the possession of a controlled substance in cause number 2021 CR 10719. We're going to reset your sentencing. We're going to ask for a mental health evaluation as well as a substance abuse evaluation. And if any of those evaluations require inpatient treatment or recommend inpatient treatment, you agree as part of this plea bargain agreement that you will attend residential treatment. 200 hours community service, no contact order with Angelina Corina Vargas until the BIPP and the parenting classes are complete, and the DDRF evaluation and recommendations. No weapons, affirmative finding of deadly weapon and moral recognition therapy classes. It all got cut off there at the bottom.
Yeah, it should be an affirmative finding of family violence, Judge.
Yeah, I'll correct that. I'll write it in down here.
Okay,
the
thank you,
third,
Judge.
that's the third correction I'll make down here, just so it's clear. Is that your understanding of the agreement, Mr. Rodriguez, in this case?
Yes, ma'am.
Move on to the assault of a pregnant person. It actually looks identical. So the state is recommending deferred for a period of 6 years, $1,000 fine. Same cases will run concurrent, same case will be dismissed. We're going to reset for a TAP and a DDRF evaluation and inpatient treatment if recommended, 200 hours of community service, and the same conditions as in 114. Is that your understanding of the agreement in that case?
Yes, ma'am.
Let's look at the evading arrest or detention in a motor vehicle, $1,000 fine, 6 years deferred, same cases running concurrent, same case, same evaluations.
I put the $57 lab fee for the case that's being TIC'd on that case, Judge.
I do see that, $57 in restitution, same conditions, 200 hours community service, all of the same conditions as before. No weapons, moral recognition therapy class, DDRF evaluation, and follow the recommendations. Is that your understanding in this case?
Yes, ma'am.
Let's start with the ag assault deadly weapon. What is your plea? Is it guilty, not guilty, or no contest? Mr. Rodriguez?
Yes, ma'am. Guilty, ma'am.
What is your plea in the ag assault deadly weapon? Is it guilty, not guilty, or no contest?
Guilty, ma'am.
And in the count 2, assault of a pregnant person, is that guilty, not guilty, or no contest?
Guilty, ma'am.
And on the evading arrest in a motor vehicle, is that guilty, not guilty, or no contest?
Guilty, ma'am.
In each of these matters, are you entering a plea of guilty because you are guilty and for no other reason?
Yes, ma'am.
Has anyone forced you to enter a plea of guilty
No, ma'am.
or offered you anything in exchange for your plea of guilty?
No, ma'am.
I will accept your plea of guilty in each of these cases. I do find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers State's Exhibit 1 and its attachment in each case.
No objections, Judge.
States 1 is admitted in each of these cases. Mr. Castañon, are you satisfied the state complied with Article 3914 in each of these matters?
Yes, Judge.
I will sign the discovery acknowledgement in each of these matters, and I will make it part of the record. Okay, give me just a few minutes.
Make sure that you let her ride by herself.
Yes, ma'am, that's fine. Okay, thank you.
Let's go back on the record, please. I do find the evidence is sufficient to substantiate your guilt. I did not make any other findings at this time. We're going to reset this matter for the results of the DDRF.
How soon can we get a TAP evaluation PSI done, Judge?
For the DDRF, it is a little bit longer. Ashley, Bianca, what do you have on your end for the DDRF? March 7th for the first. So we're gonna have to reset this to March the.
And Judge, if I could, my client does have a broken leg that is not being treated there at the jail. He's not, they even took away his crutches. Yeah, he's in the I guess hospital unit there, but he has not been treated for that. And so I don't know what we can do to try and
There's no way on the DDRF. We are so backlogged. There's no way to move that up. We just don't have enough providers.
Would you be willing to grant a PR bond with house arrest, waiving GPS fees while he waits sentencing?
He doesn't qualify on the family violence cases.
We can do a low bond with GPS. Maybe he's able to.
I'll order a PR bond report because there is some mention about a Colorado protective order in the STIP. So I want to see what that's about. What I could do is I could order a PR bond report, and that tells me everything I need to know about his history and his risk assessment. I'll do that.
Okay,
But
Judge.
right now I have to give it a setting so we can snatch that appointment before someone else is taking it.
We literally have 1, 2, 3, 4, 5, 6 different offense dates, Judge, just FYI.
The PR bond will give me everything. So let's do March the 14th. That's a Monday. Because if he's getting evaluated on the 7th, we'll know if he qualifies to go to the second screening, and then we'll know some more. March 7th. I'll also find out about his treatment, why it's not happening. All right, I need you to go in a breakout room, young man. I need you to go in a breakout room with probation, and they're gonna set you up for those evaluations. You have to sign some paperwork as well, okay? You already did all that? So he's ready to go, he can go back? All right, we're gonna go off the record, and I'll reset this for March 14th. All right, thank you.
Thank you, Judge.
We at 1:30, Judge.
1:30.
See you at 1:30, Judge.
Okay, thank you.
Judge, did Victoria reset Alcala?
Yes. February 28th, they want a trial.